Hello everyone. I hope you're safe and having good health. In this lecture, I'm going to explain some other features of the Constitution of 1956. But before doing so, let me very briefly discuss the conventional parliamentary system because many of you have asked for it. So we can determine whether a parliamentary system is conventional or not on the basis of the relationship between the head of the government and head of the state. So if the head of the state has no discretionary power and he or she has to act on the advice of the prime minister or the cabinet, we may say that this is a conventional parliamentary system, and this is how it is working in Britain and India. But if the head of the state has some discretionary powers and he or she can reject some of the advice of the cabinet, so we can say that this is not a conventional parliamentary system. So if you look at Great Britain, the Queen is the head of the state. She does not have any discretionary power. She is to act on the advice of the cabinet or the prime minister. The same is the case with India, where the president does not have any discretionary powers. Rather, he is to act on the advice of the prime minister and the cabinet. So we may say that in these two countries, the parliamentary system is conventional. But if you look at the Constitution of 1956, especially with reference to its provision on the parliamentary system, the president did have some discretionary power. In some cases, he could have refused to accept the advice of the prime minister and cabinet. So we can say that the parliamentary system under the Constitution of 1956 was not conventional. So let me now explain some other features of the Constitution of 1956. The first one is federalism. The Constitution of 1956 provided for a federal form of government. It means that Pakistan under the Constitution of 1956 was a federation of two provinces, the province of East Pakistan and the province of West Pakistan. A federation is generally permanent union of states or provinces where the states or the provinces as federating units have some autonomy, but they do not have sovereignty. And in federations, there is a government at least at two levels, at the central level and at the level of the federating units. And the powers are divided between these two levels of the government by the constitution. So we can say that division of power is the defining characteristics of federalism. So Pakistan under the Constitution of 1956 was a federation with two provinces. There was a central government and there was also a government at the level of the provinces. And according to the Constitution, the power between the center and the provinces was divided with the help of three lists: federal list, provincial list, and concurrent list. Federal list consisted of 30 items. It means the central legislature had the power to make laws on 30 issues, which include foreign affairs, defense, immigration, citizenship, communication, international and interprovincial trade, minerals, gas, oil, etc., etc. Whereas the provincial list consisted of 94 items. It means that the provincial legislatures had the power to make laws on 94 issues, which include local bodies, law and order, police, education, public health, irrigation, agriculture, sanitation, development, and many others. And there was also a concurrent list consisting of 19 items. A concurrent list is one that consists of the common subject on which both center and the provincial legislature had the power to make laws. But there was a provision in the Constitution of 1956 if the provincial and the central legislature made a law on the same subject, but the laws were in conflict with each other, the central law would prevail. So there was also a provision for a tribunal to be constituted by the Chief Justice of Pakistan under Article 129 to resolve any of the dispute between the central government and a provincial government or between the provincial governments. And then there was also provision under Article 130 for the president to constitute an inter-provincial council that would serve as a forum where the provinces would express their concerns, issues, grievances, discuss them, and seek the resolution. But during the lifetime of the Constitution of 1956, neither the Commission, Tribunal, nor the Interprovincial Council could be established. So if we look at the distribution of power under the Constitution of 1956, so we can say that theoretically it provided for a beautiful arrangement for provincial autonomy. But the practically situation was quite different, as the central government had different ways through which it could intervene in the provincial affairs. Like the central government could make the laws for any part of a province in order to implement a treaty. But the other way to intervene in the provincial affair was relatively more dangerous and effective. It was through the proclamation of emergency. Article 191 to 193 contained the provisions for the proclamation of emergency. So under the Constitution of 1956, the federal government could impose emergency on any part of the country, especially in a province, if there was an external threat or internal disturbance that was beyond the control of that province. So in this case, the emergency imposed would be called administrative emergency. There was another situation where emergency could be imposed, but it was economic emergency. If the federal government received a report from the governor of a particular province that the economic situation of a province was very bad and the province was at the verge of bankruptcy, the federal government could impose financial emergency on that particular province. And there was another situation as well for the implementation of constitutional emergency if the federal government received a report from the governor of a particular province that the system of a province could not be run according to the constitution, or the constitutional machinery in a province had broken down, then the federal government could impose the constitutional emergency on that particular province. The net effect of all three kinds of emergency could be almost similar. Like the provincial government could be dismissed, provincial legislature could be suspended, governor could have been given all the executive powers. The National Assembly could make laws for that particular province, and the governor had to make the economic policies according to the instructions of the federal government. So, in this way, the federal government could intervene in the provincial affairs, and these were very dangerous provisions, and these provisions could undermine the provincial autonomy of a province. And in this way, we can say that the federal government had upper hand.